Hi, so today I'm going to introduce useful articles, principally in the form of introducing Star Athletica to set up the issues that we're going to be talking about in class. Um, the statutory language indicates that if a PGS work, pictorial, graphic, or sculptural work, is a useful article, and we get a definition, an article having an intrinsic utilitarian function, not merely to portray the appearance of the article or to convey information, then the copyright exists and covers only features that can be identified separately from and are capable of existing independently of the utilitarian aspects of the article. So, as you will see, Justice Thomas's contempt for legislative history leaves him with not much to go on when interpreting the act in Star Athletica. The legislative history is where we got physical and conceptual separability as concepts that courts used for decades until Star Athletica. So what does Star Athletica hold? Footnote to our discussion, there's a separate challenge to copyrightability about the originality of the designs, which the majority does not reach. The problem that the dissent identifies, that this just seems like a few stripes in the abstract, so that's a problem for originality. It's also a question of what constitutes savoir-faire in the cheerleading genre. So here are some relevant images of the uniform at issue. And note that the claim in theory does not cover the team name or the colors. That is, you get to choose your team name or your colors. What Star Athletica is claiming is this design on the left here. The test provided by the court for separability says there are two parts. First, the copyrightability can be identified separately from, and second, that it is capable of existing independently of the utilitarian aspects of the article. It's easy to do the first part. You spot some 2 or 3 dimensional element that appears to have pictorial, graphic, or sculptural qualities. Now, is there any 2D or 3D object that lacks pictorial, graphic, or sculptural qualities? I think the answer must be no. There is no object that you could not make a picture of or make a sculpture of. Part 2 is therefore the only part of the test that does any work. The feature must be able to exist as its own PGS work once it is imagined apart from the useful article. But why isn't that part 2 also true of any 2D or 3D object? So if I make a spoon out of silly putty, my silly putty sculpture will exist independently of the aspects of the spoon that make it function as a spoon. It's not enough, therefore, to imagine that the article is non-functional. Justice Thomas offers the example of a sculpture of a car. And he says something quite interesting. The sculpture may be copyrightable, but that affords no right to control the manufacture of the car. A question we will discuss in class is, in that case, what does he mean when he says the sculpture of the car may be copyrightable? What about the sculpture of the car might be copyrightable? In terms of the uniforms actually at issue, the protection of the cheerleader uniform designs, the majority says follows from the test. And if you imaginatively remove the surface decorations from the uniforms and you apply them in another medium, that wouldn't replicate the uniform itself. But remember, the court is clear that although anyone can replicate the cut of the uniform, other people can't reproduce the protected design, whether on useful articles or otherwise. That means that the defendant's cheerleader uniforms can infringe the designs. And if that's so, it's much less clear why a sculpture of a car, if copyrightable, would not also afford the car maker control over competing car manufacturers. So Justice Thomas's statement that the car sculpture affords no control over the manufacturer of the car is based on section 113B of the Act, which he doesn't actually cite or quote at all. And you can see why, because it doesn't actually make any sense as pure text on its own. You actually have to know a lot about what the law was and decide what it was. And that's sort of antithetical to his preferred theory of constitutional and statutory interpretation. So we ignore it, but we sort of recognize it because he's referring to section 113B. So there's some sort of limit on what the copyright in an image of something affords you in terms of control over the thing itself. In addition, the majority says that it doesn't matter that the designs track the outline of a cheerleading uniform because lots of designs track the dimensions of things they're applied to, which is a fair point. But note what's going on here. If the protected design is really a 2D design wrapped around a 3D garment, and the work does not include the design's arrangement in space, then the originality problem looms much larger because the work itself now involves significantly fewer choices. The majority says that varsity has no right to prohibit any person from making a cheerleading uniform of identical shape, cut, and dimensions versus the ones on which the decorations in this case appear. So part of what it means perhaps is that the only copyrightable material is the chevrons, not 3D. But that might not help us figure out what to do with a car where it really is 3D. If cars and cheerleading uniforms prove too confounding, maybe we can try again with another ordinary object. The majority drops a footnote. If a shovel included any artistic features that could be perceived as art apart from the shovel, and which would qualify as protectable PGS works on their own or in another medium, they could be copyrighted, but a shovel as a shovel cannot. So here's a bunch of different possible shovel designs. Under Star Athletica, are any of them copyrightable? Remember, if the shovel design is the same as the uniform design, the copyright owner has the right to prevent the design from being applied to any useful article, including a shovel. The majority says that the shovel as shovel is not copyrightable. That still sort of suggests that the shovel as a design is copyrightable. This seems weird, among other things, because Congress clearly meant to exclude something from copyright protection, at least some useful articles. The test was supposed to do some work, and this test does not obviously do that unless we add in the other principles like merger and savoir-faire and originality that already exist and don't need separability. So another question for class would be, what about an award in the shape of a shovel? How would the majority analyze this one? So I participated in amicus advocating something more in tune with the dissent. Our argument was, and it failed, Congress was attempting to distinguish between industrial design, which is the proper subject matter of design patent, and applied art, which is the proper subject matter of copyright. Conceptual separability in this view is basically a tag along to physical separability. The majority is absolutely right that it shouldn't matter if separating the lamp, in our example, from its sculptural base would destroy the sculpture. The fact that the sculpture wouldn't physically survive the separation doesn't preclude a finding of conceptual separability between the sculpture and the part of the lamp that gives light. But the majority then says it doesn't matter if the thing that you imagine as the PGS work would remove functional features from the useful article, as long as you can still imagine the PGS work separately from the underlying useful article. The extra step that many people previously took of essentially imagining a featureless lamp base replacing the sculpture isn't really necessary. That argument, I think, is sensible in itself. It's true, without the base, the lamp is just a socket and dangling wires, as shown on the right. But framing the test in that way is not any help in identifying articles that lack any copyrightable content at all. All the work on that front is now done by originality, merger, savoir-faire, similar doctrines, making it mysterious why Congress would need to write anything in the statute at all about useful articles. The majority is also conflating two arguments. One is that the PGS work can't contain any elements that make the useful article function. That argument is rejected on the perfectly understandable reasoning that the presence of the sculpture in our lamp sculpture holds up the rest of the lamp. So the sculpture is functional in a practical de facto sense. The other argument, though, which the majority fails to grapple with, is that the protectable elements of the PGS work shouldn't ever contain any elements that make the article better at doing the useful, non-aesthetic part of its job. This is what we would call de jure functionality in trademark law. The presence of the sculpture does not make the lamp any better at lighting. If it did, it shouldn't be protectable under copyright, although patent might well be appropriate. The reason that the majority can fail to make this distinction is the very fraught function of cheerleading uniforms. The functionality argument was that these designs had an effect on the audience's perception of the cheerleader's body, not just on the audience's perception of the uniform itself, that the body looks slimmer as a result of design choices involving the use of stripes and angles. Your casebook authors made this argument in an amicus of their own. It seems to me that one can reject this argument and conclude that the aesthetic effect of enhancing other objects is still informational and therefore not useful, and still argue that anything truly functional, like the shovel, is completely unprotectable, even if it is beautifully designed. Beautiful designs can always be taken care of by design patent. Side note here, the originality standard for granting design patents is really low, and there's an amazing payoff, which is that you get the infringer's entire profits on the infringing article, no matter how little the design contributed to the sales of the article. Anyway, the majority says we don't need to worry about the physical and conceptual division. To me, this is an example of the trouble with ignoring legislative history. You don't know what to make of the words of the statute themselves. So it doesn't matter that Congress was very clear that it wanted to treat industrial design separately. Anyway, perhaps the shape, cut, and physical dimensions of the uniforms remain unprotected by copyright. So design patent might still have some extra subject matter there, perhaps even utility patent have some subject matter there to be distinct from what copyright automatically protects. Now, there is one limiting principle that the court offers. To qualify as a PGS work on its own, the feature cannot itself be a useful article. This is not quite the same as the actual statutory language. On its face, the statute refers to utilitarian aspects of the article, not the article as a whole. That may make a difference in appropriate cases. So you could read the court's language here as precluding protection for the shape of most useful articles, as long as those useful articles lack non-functional embellishments. So maybe the shovel is just not protectable at all. The court also then says there necessarily would be some aspects of the original useful article left behind if the feature were conceptually removed. There can't be zero left on one side when you do your imaginative separation. So that again suggests that an entire shape may be unprotected. The more that an article's form follows its function, the less will be left behind after the extraction step. So the dissent says this discussion in the majority is all well and good, but look what Star Athletica is claiming based on the registration. Star Athletica is claiming the uniforms themselves as cut and shaped. Those pictures they registered are certainly protectable by copyright, but that shouldn't make the underlying uniforms protectable as uniforms any more than the existence of a copyrightable picture of a car makes the car design copyrightable. The dissent continues. The majority is mostly right, but you should ask, when I imagine this separate PGS work, am I imagining a picture or sculpture of a useful article or a part thereof? If I am, then there is no separability. This also has the benefit of adhering more closely to the statutory language about utilitarian aspects of an article. A bold court could probably look to the dissent for guidance, given that the dissent says it's applying the majority's own test. This is probably especially true with respect to 3D objects, as opposed to the 2D designs like the cheerleader uniforms. But the majority's holding still leaves us with the nagging feeling that all useful articles might have something copyrightable about them, unless the necessary originality is lacking. By contrast, the dissent is quite clear that some useful articles are not copyrightable, even if they possess originality, because they do not possess separability. So with that, I'll finish up and we will get into the many complications of the opinion in class.